In preparation for receiving or submitting an offer to purchase or a letter of intent in the sale and purchase of a business, today we're going to explore binding versus non-binding agreements and conditions, typical in such documents. Though many consider letters of intent and in some cases offers to purchase non-binding, the reality is that most have some binding conditions. A non-binding agreement is designed to outline a proposed arrangement between the parties without legal obligation to the parties. Naturally, depending on the intent of each respective party, this could be desired or not. A binding agreement, on the other hand, is a legally binding contract, enforceable at law and with specific obligations on the parties. A non-binding agreement will specifically outline that the document is non-binding. Be aware that it may also state this document is non-binding on the parties save and except specific conditions and will reference the specific binding paragraphs or sections. Most often these agreements, whether binding or not, have so-called conditions. These conditions can be conditions precedent or conditions subsequent. Conditions precedent are ones where the binding obligations on the benefiting party are subject to the satisfaction of certain outstanding conditions, meaning that there is no deal until the conditions are fulfilled, satisfied, or waived by the buyer, and where the obligations of the parties terminate, save and except specific obligations listed as binding. These could be non-disclosure, confidentiality, and possibly others. These conditions precedent are also often referred to as subjects, and typically include such things as financing, clearances or discharges, assessment of contracts or specific assets, specific approvals, and other such conditions that must be satisfied before the buyer's obligations to the proposed transaction become binding. Conditions subsequent, on the other hand, as the term implies, refer to the conditions which occur after the formation of a contract or after the closing and are often referenced in our agreement as conditions of closing. These are conditions that survive the closing and refer to occurrences which must take place or where such absence or deficiency could be deemed a breach of contract and subject to remedial or other actions, including more severe legal consequences. Conditions are often informally referred to as outs or escape clauses because a failure by one party to satisfy the conditions enables the other party to get out of the contract. For this reason, it is important for you to know and understand what the conditions are in any given document and able to identify binding versus non-binding documents and conditions. A professional certified business intermediary from Pacific Business Brokers is well versed in such contractual language and able to bring clarity when drafting or considering an offer to purchase or a letter of intent.